So imagine this. You've lived in the UK lawfully for over 10 years. You came as a student and then eventually extended your visa to a Tier 1 general migrant. You get married, you have children who are born in the UK. You have long-term plans of settling, dreams, ambitions. But first you need to make an application for indefinite leave to remain, and then after that, you'll qualify for British citizenship. You make an application to the Home Office for indefinite leave to remain, but your application is refused. And all of a sudden you're required to leave the United Kingdom within 14 days. There is no right of appeal. You can ask the Home Office to review the decision, but that's it. And if you decide to ask for a review, you can't provide any new evidence to explain your case either. And if you want to challenge it any further, you can only do so by judicial review, the cost of which runs into thousands of pounds. Why? Well, because there was a discrepancy between the self-employed earnings shown in your previous Tier 1 application for an extension of leave and the amount you declared to the HMRC. And as far as the Home Office is concerned, you have been dishonest, deceitful, and therefore your character and conduct make it undesirable for you to continue to remain in the UK. And just like that, you become an illegal immigrant, an overstayer, a non-person. Under the Hostile Immigration Act 2014, you no longer have the right to work, rent accommodation, operate a bank account, drive a car, or access the NHS. If you want to stay in the UK to fight your case, you're forced into a life of destitution, debt, despair, and mental health issues. Now, sadly and unfortunately, this is a real-life scenario that thousands of people encountered after having to make applications for indefinite leave to remain with the Home Office. Now, the Tier 1 General Migrant category was introduced in 2008. It was introduced to replace the Highly Skilled Migrant Programme. It was intended to provide a route for migrants looking to find highly skilled employment in the UK. Unfortunately, according to the Home Office, many applicants claimed points for earnings that were not genuine, and as a result of widespread abuse, this route, the Tier 1 General route, was closed to new applicants in 2011. Now, in May-June 2016, the HMRC identified a pattern in which people who had previously submitted tax returns that were on the lower threshold, which meant that little or no tax were paid, were resubmitting recalculated tax assessments, which meant that their earnings were higher and there was higher tax to pay. The Home Office then took a view that, look, these applicants must have misled the HMRC in regards to their true level of earnings, and therefore decided to rely on paragraph 322, subparagraph 5, in relation to their conduct and their character. Paragraph 3225 is a non-mandatory or a discretionary ground of refusal, and it says the undesirability of permitting the person concerned to remain in the United Kingdom in the light of his conduct, including convictions which do not fall within paragraph 3221C, character or associations, or the fact that he represents a threat to national security. Now, the way the Home Office handled this raised concerns, and in fact the matter was raised in Parliament. Concerns that were raised that applicants were being wrongly refused when their only failing was that they had made minor tax errors. There were over 70 applications for permission to appeal or appeals pending before the Court of Appeal, and an unknown amount of challenges at the First Tier Tribunal and Upper Tribunal challenging the lawfulness of the Home Office's approach in refusing these cases under 322 subparagraph 5. Now, this is what the Court of Appeal decided. A discrepancy between the earnings declared to HMRC and to the Home Office may justifiably give rise to a suspicion that it is the result of dishonesty, but it does not by itself justify a conclusion to that effect. What it does is to call for an explanation. If an explanation once sought is not forthcoming or is unconvincing, it may at that point be legitimate for the Secretary of State to infer dishonesty. But even in that case, the position is not that there is a legal burden on the applicant to disprove dishonesty. Where the Secretary of State is minded to refuse ILR on the basis of paragraph 322 subparagraph 5, on the basis of the applicant's dishonesty or other reprehensible conduct, he is required as a matter of procedural fairness to indicate clearly to the applicant that he has that suspicion, to give the applicant an opportunity to respond, both as regards the conduct itself and regards any other reasons relied on as regards undesirability. In our view, the making of a decision which both deprives the applicant of leave to remain and, as the necessary corollary, renders him or her liable to immediate removal as set out in the enforcement warning, is in itself an interference with their Article 8 rights. It cannot be the case that a migrant's Article 8 rights are not engaged until the moment of the knock on the door. Where the Secretary of State has alleged dishonesty, that will normally require the tribunal, whether the first tier tribunal on an appeal or the upper tribunal on a claim for judicial review, to give the claimant an opportunity to adduce evidence in rebuttal. And given that credibility will be an issue, that will normally include an opportunity to give oral evidence himself or herself and or call relevant witnesses to give oral evidence. So there we have it. The Court of Appeal say, listen, if you are refused an application for settlement, you should be able to appeal against it on the basis that it has interfered with your Article 8 human rights. This is a right that wasn't afforded to the applicants previously before this judgment was handed down. Because remember, when they made these decisions, they just had no care as to whether or not you had a family life, whether or not you had a private life, whether or not you had children here, whether or not or how long you had lived here. It was just go now, leave the country. The Court of Appeal also said it's not fair to make allegations against an applicant and not give that applicant a fair opportunity to respond or provide evidence to rebut the presumption of dishonesty. Where does this leave the landscape? Well, I presume now that a lot of the applications that are pending at the Court of Appeal will probably be eventually remitted back to a first tier tribunal to look at the facts of the case. If you've made an application in the past and you have been refused on these grounds, then it may be open to you to make an application to the tribunal, filing an appeal out of time on the basis of this judgment. I assume that some guidance will soon be handed down, but certainly this opens the door for people who have been wrongly refused by the Home Office to challenge those refusals, irrespective of how long ago those decisions were made. If they were made unfairly, and this applies to people who have already left, because there's an estimate that over 400 people were forced to leave due to these type of refusals. All right, my name is Obi Wokeji. I'm signing out, and this is Legal Pepper Soup. Catch you up next time.